Did you know that millions of Californians could be forced out of their homes starting March 2026? Yes, you heard that right. Experts are calling it one of the biggest housing shocks in decades. Families who thought they were safe, tenants who never missed a payment, could suddenly find themselves staring at an eviction notice with almost no time to respond. The new laws are stirring fear and uncertainty across the state, and many people don't even realize the danger until it's too late. What makes this even more alarming is that these changes aren't just for problem tenants. Landlords now have broader powers, and the rules are being rewritten in ways that could catch even the most careful renters off guard. From tighter sublease rules to shortened notice periods, the shift is dramatic, and it could hit anyone renting a home or apartment. So what exactly is changing? How could it affect you or someone you know? In this video, we're breaking down 10 shocking ways these new eviction laws could remove millions from their homes, and what you can do right now to protect yourself. Stick around, you won't want to miss a single detail. Number 1. Expanded grounds for eviction. The first and perhaps most shocking change in California's March 2026 eviction laws is the expanded list of reasons landlords can legally remove tenants. In the past, evictions were mostly limited to serious issues like non-payment of rent or major lease violations. But now, the laws are broadening the scope, allowing landlords to claim eviction for reasons that were previously considered minor or questionable. This means that even tenants who pay on time and follow all the rules could suddenly find themselves at risk. Experts warned that these expanded grounds for eviction could affect millions of renters, especially in urban areas where demand for housing is high. For example, landlords might now cite reasons like minor property modifications, subleasing without detailed approval, or even personal use of the property as a valid cause. The change is subtle but powerful. It gives landlords much more leverage in the rental market. So, what can tenants do to protect themselves? First, it's crucial to review your lease in detail, paying attention to any clauses that could be interpreted in the landlord's favor. Documenting everything from rent payments to maintenance requests is essential because in disputes, records are your strongest defense. It's also wise to stay informed about local tenant rights groups. They can provide legal guidance if you ever receive an eviction notice. While it may seem overwhelming, knowing your rights and taking proactive steps can make the difference between keeping your home and facing sudden displacement. We've poured hours into uncovering these shocking changes just for you. So if this video helped you, hit subscribe, drop a comment with your thoughts, and join our community. It's just one click, but it keeps you informed and protected. Number 2. Shortened notice periods. Another alarming change in California's March 2026 eviction laws is the dramatic reduction in notice periods. Before, tenants typically had several weeks, sometimes months, to respond to an eviction notice, giving them a chance to resolve issues or prepare for moving. But under the new rules, landlords can now give notice periods that are significantly shorter, leaving tenants with very little time to react. This creates a sense of urgency and panic, especially for families who may not have backup housing ready. The implications are huge. With a shorter notice period, there's less time to gather legal help, negotiate with landlords, or secure alternative housing. Many renters could be blindsided, receiving a notice one day and facing court or forced relocation within weeks. Studies of eviction patterns in states with similar laws show that tenants with limited notice are far more likely to face displacement, highlighting just how serious this change can be. So, what can you do to protect yourself? First, know your lease and local rules inside out, because understanding the exact notice requirements could buy you critical time. Second, keep all documents organized, rent receipts, emails, maintenance requests, so you can prove your compliance immediately if needed. Finally, connect with local tenant advocacy groups or legal aid organizations. They can act quickly to help you fight unjust evictions. Shortened notice periods are designed to push tenants into quick decisions, but with preparation, you can stay one step ahead. Number 3. Loopholes in rent control. One of the most unsettling aspects of the new California eviction laws is the emergence of loopholes in rent control protections. Rent control departments have long been a lifeline for many Californians, providing a sense of security and stability. But under the March 2026 changes, certain units that were previously shielded from eviction could now be vulnerable to new landlord claims. Experts warned that these loopholes are subtle, often buried in legal language, yet they could have devastating consequences for tenants who assumed they were fully protected. For example, landlords may now exploit clauses related to property renovations, personal use, or tenant behavior that was previously overlooked. Even long-term tenants who have faithfully followed all lease agreements could find themselves targeted under these revised rules. Analysts predict that urban areas with high rent control coverage could see a spike in eviction filings, creating both fear and uncertainty for renters who once felt safe. So, what can you do if your home is at risk? First, it's essential to verify whether your apartment still qualifies for full rent control protections under the new laws. Second, keep meticulous records of rent payments, communications, and any lease agreements. This documentation is your first line of defense. Finally, reach out to local tenant rights organizations for guidance. They can help you identify potential loopholes before they become a serious threat. Knowledge and preparation are your best tools to navigate these tricky legal waters and protect your home. We've spent hours digging into these hidden loopholes just for you. So if this video helped you understand your rights, subscribe with one click. Share your thoughts in the comments and help us keep everyone informed and protected. Number 4. Increased eviction for personal use. One of the most controversial changes in the March 2026 California eviction laws is the expanded allowance for evictions under the guise of personal use. Previously, landlords could only claim personal use of a unit under strict conditions. But now, the rules are being stretched, giving landlords more freedom to evict tenants, even if they have been perfect renters. This change is causing widespread concern because it's vague and open to interpretation, leaving tenants exposed to sudden displacement. Legal experts warn that landlords may now use personal use to justify eviction for a wide range of reasons, such as wanting to move a family member in, convert a rental into a short-term rental, or even renovate for personal projects. Tenants who assumed they were secure could wake up to eviction notices that seem legitimate on paper but feel unfair or shocking in practice. This creates a high-stress environment where families and individuals may feel powerless in the face of legal technicalities. So what can tenants do to stay protected? First, always request written proof of the landlord's intent to occupy the unit personally. Verbal claims alone are not enough. Second, consult with tenant rights organizations or legal professionals immediately if you receive a notice. Documentation, such as your lease history and communication records, can be crucial in disputing questionable evictions. Finally, stay informed about updates and local court interpretations, because rules can vary by county and may affect how personal use is enforced. We've worked tirelessly to uncover these shocking changes for you, so if this video gave you vital insights, subscribe with just one click. Drop a comment sharing your experience and help protect thousands of renters like you. Number 5. Stricter rules on subleasing. Another alarming aspect of California's March 2026 eviction laws is the tightening of subleasing rules, which could put many tenants at risk of eviction for actions that were previously harmless. Subleasing has long been a way for renters to manage high costs or temporarily share space, but the new regulations give landlords much more authority to penalize tenants for even minor violations. This change is especially concerning for those living in larger cities, where housing costs are skyrocketing and shared living is common. Under these new rules, unauthorized subleasing, even for a few weeks or to a close friend, could now be considered a legitimate reason for eviction. Landlords are being given more power to interpret lease agreements strictly, and courts are expected to side more frequently with property owners. For many tenants, this means that a small oversight or misunderstanding could suddenly turn into a legal battle or forced move. So, how can tenants protect themselves? First, always get written approval before subleasing any part of your rental unit. This simple step can prevent disputes and provide a paper trail in case of legal challenges. Landlords are being given more power to interpret lease agreements strictly, and courts are expected to side more frequently with property owners. For many tenants, this means that a small oversight or misunderstanding could suddenly turn into a legal battle or forced move. So, how can tenants protect themselves? First, always get written approval before subleasing any part of your rental unit. This simple step can prevent disputes and provide a paper trail in case of legal challenges. Second, keep copies of all communications with your landlord regarding subleasing. Lastly, familiarize yourself with local tenant laws, because some cities may still provide limited protection for short-term arrangements or emergency sublets. Being proactive can make the difference between keeping your home and facing sudden eviction. We've poured countless hours into breaking down these critical changes just for you. So, if this video gave you valuable protection tips, subscribe with one click. Share your story in the comments and help us empower thousands of renters across California. Number 6. Impact on low-income families. One of the most concerning consequences of California's March 2026 eviction laws is their disproportionate impact on low-income families. While the laws affect all tenants, studies show that those with limited financial resources are far more vulnerable to sudden evictions. Families who are already struggling to make ends meet could be pushed out of their homes, creating a wave of housing insecurity that experts are calling unprecedented. This isn't just a number, it's millions of people, children and working families facing uncertainty in their own homes. Low-income tenants often have fewer resources to fight eviction legally, and shorter notice periods or expanded eviction grounds make it harder to respond effectively. Even minor lease infractions or disputes over personal use or subleasing could escalate quickly, leaving families with very little time to find alternative housing. The human toll is significant. Families may have to split up, move far from work or schools, or rely on emergency shelters. So, what can families do to prepare? First, it's essential to know your rights and connect with local tenant advocacy or legal aid groups immediately. Second, keep meticulous records of all payments, communication, and lease agreements. These can be your strongest defense. Third, explore state and city rental assistance programs before a crisis hits. While the changes are daunting, being informed and proactive can help protect your family from sudden displacement and give you a fighting chance in this uncertain housing landscape. We've spent countless hours uncovering how these laws could impact families just like yours. So, if this video opened your eyes, subscribe with one click, leave a comment sharing your experience, and help us protect communities across California. Number 7, digital rent payment tracking. A surprising yet powerful tool in the March 2026 California eviction laws is the increased use of digital rent payment tracking. Landlords are now relying heavily on online platforms to monitor payments in real time, making it easier than ever to detect even minor delays. What might have been a small, understandable mistake, like a payment arriving a day late, can now trigger formal eviction procedures. For tenants who aren't careful, this could turn an otherwise stable situation into a legal nightmare almost overnight. Digital tracking gives landlords more leverage and faster action, reducing the time tenants have to resolve disputes. While technology can make life easier, in this case, it removes the flexibility that many renters once relied on. Missed payments, technical errors, or banking delays that used to be easily corrected could now be used as a reason for eviction. Studies from other states with similar systems show that tenants unfamiliar with digital tools face higher eviction risks, highlighting how critical it is to adapt quickly. So, how can tenants protect themselves? First, consider setting up automated rent payments to ensure every transaction is timely. Second, keep detailed records of all transactions, including screenshots or confirmations to prove payments were made on time. Finally, communicate proactively with your landlord if there are any delays. Documentation of good faith effort can sometimes prevent unnecessary eviction filings. By understanding how these digital systems work and preparing in advance, tenants can stay one step ahead and avoid being unfairly targeted. Number 8. Limited court challenges. One of the most worrying consequences of California's March 2026 eviction laws is the reduction in tenants' ability to challenge evictions in court. Previously, renters often had weeks or months to dispute notices, present evidence, and fight for their right to stay. But the new regulations are streamlining the eviction process in favor of landlords, making it harder for tenants to defend themselves effectively. This shift creates an environment where even minor issues can quickly escalate into a forced move, leaving families and individuals scrambling. Legal analysts warn that these changes could disproportionately affect tenants who lack experience navigating the legal system. Shorter hearings, stricter documentation requirements, and faster court timelines mean that tenants must act immediately or risk losing their home without a fair chance to present their case. Even those who believe they are fully compliant with their lease agreements may find themselves facing eviction due to technicalities or small misunderstandings. So, how can tenants protect themselves under these tighter rules? First, consult a qualified tenant attorney or legal aid organization as soon as you receive a notice. Time is critical, and early action can make all the difference. Second, organize and document everything from rent receipts to maintenance requests to provide clear evidence of your compliance. Third, stay informed about local court procedures because differences in county interpretations can impact outcomes. While the changes are intimidating, being proactive, organized, and knowledgeable can help you navigate these limited court challenges and protect your home from sudden eviction. We've worked tirelessly to uncover these urgent legal changes just for you. So, if this video helped you understand your rights, subscribe with one click. Drop a comment sharing your experience and help us protect tenants across California. Number 9. Impact on homeowners renting out units. While much of the focus is on renters, California's March 2026 eviction laws also significantly affect homeowners who rent out rooms, ADUs, or secondary units. These homeowners, who often rely on rental income to cover mortgages or bills, now face stricter regulations and increased legal scrutiny. Even if you've been renting responsibly for years, minor mistakes or misunderstandings could trigger eviction disputes, making this law a concern for both renters and property owners. Under the new rules, homeowners could be held to stricter documentation and approval standards, particularly when renting to long-term tenants or informal arrangements like sublets. Courts are expected to interpret the laws more rigorously, meaning that even small disagreements over lease terms or tenant agreements could escalate into legal battles. This shift creates uncertainty, as families renting out space for extra income may now face the same legal pressures previously reserved for larger landlords. So, what steps can homeowners take to protect themselves? First, update your rental agreements to reflect all current legal requirements and clearly outline tenant responsibilities. Second, keep thorough records of payments, communications, and any permissions granted. Third, seek legal advice if you're unsure about any aspect of your rental setup. Being proactive can prevent misunderstandings from escalating and protect both your tenants and your property. These changes serve as a stark reminder that eviction laws now touch everyone involved in renting, from tenants to small-scale landlords. Knowledge, preparation, and careful documentation are your best defenses. We've put hours of research into revealing how these laws affect everyone. So if this video gave you valuable insights, subscribe with just one click. Share your story in the comments and help us keep every Californian informed and prepared. Number 10. Future uncertainty. The final reason why California's March 2026 eviction laws are causing nationwide concern is the sheer uncertainty about how they will be enforced in the future. While the new rules are now in effect, their practical implementation varies by county, and courts may interpret the regulations differently. This creates a confusing and unpredictable environment for tenants, landlords, and even small-scale property owners. For millions of Californians, the fear isn't just eviction. It's not knowing if or when it could happen to them. Legal experts warn that the combination of expanded eviction grounds, shortened notice periods, and stricter court processes makes it difficult to predict outcomes. A tenant in one city may have protections that a neighbor in another city does not. This uncertainty can lead to anxiety, rushed decisions, and even unnecessary moves as people struggle to anticipate potential risks. Families, renters, and small homeowners all face this challenge, and the lack of clarity can magnify the impact of every other change we've discussed, from personal use evictions to digital tracking of rent payments. So, what can Californians do to prepare? The first step is to stay informed. Follow updates from local housing authorities, tenant advocacy groups, and legal professionals. Second, maintain thorough documentation of every lease payment and communication. Finally, have a contingency plan in case sudden eviction becomes a possibility, even if you are fully compliant with your lease. Being proactive, organized, and aware of potential risks is the best way to protect yourself in this uncertain landscape. Knowledge isn't just power, it's security for your home and family. We've spent hours breaking down every twist of these new laws for you. So, if this video gave you critical insights, subscribe with one click, leave a comment sharing your thoughts, and help us keep Californians informed and ready. California's March 2026 eviction laws represent a dramatic shift in housing security, affecting millions of renters, homeowners, and families across the state. From expanded grounds for eviction to shortened notice periods, from loopholes and rent control to digital rent tracking, each change creates new risks and challenges that can impact anyone, even tenants who have always followed the rules. These laws are more than just legal updates. They're a wake-up call for everyone who relies on rental housing in California. We've explored 10 reasons why these changes matter, and the message is clear. No one is completely safe unless they take proactive steps. Low-income families, small-scale homeowners, and long-term tenants all face increased uncertainty. Courts may interpret the laws differently depending on the county. Subleasing rules are stricter, and personal use evictions can happen more easily than ever. Even seemingly minor actions like a late payment or a short-term sublet could put someone's home at risk. The uncertainty alone is enough to create stress and fear across communities. But there is hope. Knowledge, preparation, and documentation are your strongest defenses. Reviewing leases, maintaining payment records, consulting legal experts, and staying informed about local regulations can make the difference between keeping your home and facing sudden eviction. Awareness is power, and taking action now can protect you, your family, and your neighbors. Remember, these laws affect millions of Californians, and understanding every detail is critical. Don't wait for an eviction notice to take action. Be proactive, stay informed, and protect your home before it's too late.